Now we begin with judicial matters. Former Attorney General of the Federation, Abubakar Malami, his son, Abubakar Abdulaziz Malami, and an associate, Hajia Bashir Asabe, have been remanded in Kuje Custodial Facility. The trio pleaded not guilty to a 16-count charge of alleged money laundering and illegal acquisition of properties valued at over 8.7 billion naira. The arraignment took place today before Justice Emeka Nwite of the Federal High Court in Abuja. All right, now we cross to our correspondent, Joshua Imarayi, at the Federal High Court to give us more details of the development. Joshua, what led the court to remand Malami, his son, and their associate? All right, while we're on standby to take Joshua, we will definitely come back to him. But in the meantime, also joining us to discuss this is legal practitioner Tunji Abdulhameed. Tunji, thank you for joining us. Very quickly, I just want to find out what specific provisions of the Money Laundering Prohibition and Prevention Act 2011 as amended and the Money Laundering Prevention and Prohibition Act 2022 are allegedly breached in these charges?
Unfortunately, I have not gone through the charge. I only know that it was being charged for money laundering. So the specific act of the section of the act, I am not aware of it yet. I have not seen the charge. I'm only aware that it's being charged for money laundering today.
Okay, but let's talk about the timing then, the timing of the alleged transactions. How would this timing, that's 2015 to 2025, affect the prosecution's case, especially given that some transactions occurred while Malami was the AGF?
You see, unfortunately, in our system, when you are in the system, they don't see anything bad about what you are doing. And you remember that Malami was the Attorney General of the Federation at that time, and anyone to be charged or not to be charged will be determined by him. So you do not expect that Mr. Malami SAN will take himself to court if nobody decided to take him to court. So that was the reason why he was not taken to court, or no action was taken against him at that time. 2015, 2023, he was the Attorney General of the Federation at that time. And being the Attorney General, he has the responsibility of prosecuting people in court, and he determines which matter to be in court and which matter not to be in court. So if he's not taken to court between those periods, that explains that, because you cannot expect him to charge himself to court.
All right, please hold on.
If you have a system where the system will check itself, that could be possible. But we're in a system where we rely on individual and not institution. The president at the time does not bother, does not care. Even when you talk at that time, they'll say you are corruption is fighting back. Just like he's saying now that he's being charged to court because of a committee he set up against the current EFCC chairman. So you see, there's a lesson to people in authority today that yesterday you'll be there, you may be there, tomorrow or today you may not be there. And what you did to other people in the past may be returned to you. He was there too, doing the same thing that he's complaining now to other people while he was in the Attorney General of the Federation. It's unfortunate. That,
all right, Tunji Abdulhameed, if you can hear me, kindly hold on. We have our correspondent at the Federal High Court now. We just want to hear from him, and then we will continue the conversation. Joshua Imarayi is on standby at the Federal High Court to give us more details. Joshua, what led the court to remand Malami, his son, and their associate?
Well, good afternoon to you, Blessings. It is a judicial irony, as the same man who was at the head of the prosecutorial table of the Ministry of Justice of Nigeria is now being the one being docked for the same crime he was prosecuting people for. So what actually led to the remand of the former Minister of Justice, Abubakar Malami, his son, and one of the associates was the fact that upon commencement of proceedings this morning at the Federal High Court in Abuja before Honorable Justice Emeka Nwite, the counsel representing the defendant actually brought to the court an oral application, also informing the court that a form of application was also filed to the prosecution counsel and that they are yet to reply. Well, the court took the oral application from the defendant and also the argument of the prosecution. And the argument that the defendant actually made in court was that this case that the defendant is being tried under is not a capital offense and is actually is privileged to have bail and to be granted bail, of course. And the defense counsel also argued that the defendant does not pose a flight risk and that he's not going to abscond or abandon his trial. But this position and argument was objected by the prosecution counsel, who told the court that the issue of not absconding, of not being a flight risk, is an issue of fact, and such issue can only be brought to the court through formal application by means of affidavits and evidences.
Okay, but how did the defendant and the legal teams react to the court's decision?
Well, the defendant and the legal team seemed comfortable with its ruling because one of the counsels to the defendant actually spoke to newsmen who confirmed that it was just an oral application that was moved, that they are looking forward to the day in court where the formal application will be argued by the respective parties, particularly defense counsel and the prosecution counsel.
All right, just before we let you go, Joshua, what are the next steps in the case? When are we expecting the next hearing?
Well, Justice Emeka Nwite has adjourned to the 2nd of January 2026 to take argument for the formal application of bail brought before the court by the defendant, Abubakar Malami, as well as his son and one of the associates. But we are hearing from sources close to the investigation saying that the associate that is being arraigned alongside Abubakar Malami and his son is alleged to be his fourth wife. We are expecting confirmation from the appropriate necessary parties. But on the 2nd of January, the court will take argument for the formal bail application and maybe possibly rule on that day, or perhaps take adjournment for the ruling of the formal application.
All right, Joshua Imarayi live at the Federal High Court with the update on the money laundering case. We still have our guest with us who has been on standby as well, the legal practitioner Tunji Abdulhameed. Tunji, I just want to quickly find out, can the defense argue political persecution or bias in high-profile corruption cases? And how does Nigerian case law treat such claims?
Even if he wants to argue that it's a matter of evidence, it's a matter for trial, that will not affect, that will not be a defense to the offense that has been alleged to have been committed if the prosecutor has been able to prove his case beyond reasonable doubt. So the evidence the defender should be bringing is to counter the allegation by the what's it called, by the prosecutor. The argument that is being wind hunch or whatever will not hold water if there is no evidence to back it up. Even if it's been wind hunch, they must establish that the evidence, that the allegation against him are not correct. That is the only thing that I'm feeling. Not that mere fact that you are alleging that somebody is doing repaying you back in your own court does not. It's not a defense. The Mr. Chairman of EFCC is not. EFCC should be an institution and not an individual thing. So because you have an issue with the chairman does not mean you cannot be charged by EFCC. So what he must be preparing for is defense to the prosecution's case, and I hope that prosecution also have evidence that is tight to prove that or support their allegation against Malami. It's a matter for trial. It's not a matter for I'm being with or whatever they call it.
All right, Mr. Abdulhameed, before we let you go, what are the typical sentencing range if convicted under the relevant money laundering statutes?
Like I said, I've not seen the particular section because it's very easy. It depends. It ranges from 7, 14 years or 2, 3, 4 years. It depends. It's at the discretion of the court, but the maximum sometimes is 14 years, 7 years, 14 years. So it depends on the particular allegation and the level of allegation against it.
All right, legal practitioner Tunji Abdulhameed, thank you for joining us on the show. We'll definitely look forward to seeing how this ends.